Welcome to tonight's webinar. We have a special treat. We have our superhero ladies, Mary Austin and Lori Midttun here, that are going to go over some of the highlights that they have seen from several attorneys from a couple meetings that they had coming through. So I'm going to turn the time over to them. They've got a lot of really good tidbits. Mary and Lori are both excellent agents. If I had to sell my house, I sure would feel comfortable selling to them and selling with them. So they've got a lot of years of experience between the two of them. So take advantage of the insights that they have and the experiences and scenarios that they're going to share. And if you have questions, feel free to drop them in the chat. I'm going to be moderating as best as I can to help them both along, but there's a lot of things that they have to share. But without further ado, I'm just going to turn the time over to you two ladies.
Thanks, Shannon. Appreciate it. I'm just going to start off by saying that of all the classes that I take in the course of a year, the Legal Symposium is probably the most valuable to me in my business. So we're taking 7.5 clock hours and distilling it down to just a few minutes. And so I'm going to let Mary start off with the information, and we'll just both pipe in.
Okay, so one of our favorite speakers was Annie Fitzsimmons, the Washington Realtors attorney. And she said that we want to really be careful. And if there is a form for something, use the form and be really careful of using the form 34. And if there's anything out of the ordinary, then we should have our designated broker review. And also they said, never, ever use a form 34 in lieu of a 35R. Apparently some people have tried to do that, but when you're doing your inspection response, that needs to be on the 35R, not on a form 34, although it can be used in conjunction, but the form 34 alone will not establish the buyer's negotiation period that has been satisfied or rejected. Can you go to the next screen? And she made a really awesome point about on the form 21, and that would be the form 28 also, on the first page of the contract, there are no defaults. So everything must be properly marked and use full legal names, not the owner of record or undisclosed. Ask the buyer how they want their name to appear on the title. And if the client's name has changed at some point, if it's different, then you can use also known as or formerly known as on the addendum. They also said that love letters can easily violate federal fair housing regulations, which is something that Oregon was concerned about. So maybe a better way to communicate information is to the agent. And also they said, make sure that the utilities form 22K be completed with the offer. A lot of times if that didn't get filled in, then there can be an issue after closing and it wouldn't be covered. And they really want us to steer away from doing on or before language. Instead, use a closing date. And if it needs to change, then you can change that with the form 22Y. And then also they suggested that we do fill out a withdrawal of offer form to have our withdrawal of counteroffer form to send to our seller, have them sign it and just have it just in case something changes, but and promise them we wouldn't be sending that unless they texted us and told us it was okay to send it. And also they said that form 34 is the general addendum form is not a substitute for a counteroffer form. So if somebody tried to put the counteroffer information on a form 34, that wouldn't make that part of the contract. Next slide. And also the safest way to handle the escalation form is to provide the buyer agent with the competing offer and invite the buyers to resubmit their offer with the agreed price and terms with no escalation. There's just so much that can go wrong with the escalation form. Next slide. Oh, and then also on the financing options, they strongly suggested that one great way of not having a financing contingency is to do a Form 22A using 0 days. And that allows the buyer to conduct the appraisal, put seller on notice of contingent funds, and it takes care of everything that you want to take care of, which I'd never heard of that before, but it sounds like a great idea. And also Lori, can I get you to take the other two parts of that, please?
Yeah, this page indicates some of the ways you can work with the eliminating a financing contingency and still protect your client. And that includes the seller. Not having a financing contingency puts you in a position where the seller is not granted, or the seller's agent is not granted access to have conversations with the lender. And we know these things happen all the time, but if you want to preserve some rights for your client, for your seller, for example, that's why the third column, using a Form 22A, option B, marking 0 days, is the same as waiving your financing contingency. You want to make sure that you mark, if you're representing the seller, that that it includes the low appraisal. These other two options are available to you as well. And what you might find is that you may need to explain these things to a listing agent, and sometimes that can be a bit challenging, but even using a table like this might help them to understand why you are doing it in this fashion rather than just eliminating the 22A and maybe just having the 22EF proof of funds, and why some of these options are better to have kept in place. Any questions on that, or we can move on?
No, I'll just agree with you, Lori. I mean, it's scary to see all these waivers of financing and all this stuff, and there's so much protection by having things like that. There's a lot of confusion too in the industry where listing agents may not know what a 22AA is, or yes, they use a 22EF, but there's a loan, so they're confused on whether or not there is financing or not. So I'll just echo exactly.
There's VA financing. How are you going to get the mandatory clause signed by the seller? They're not required to.
Yeah.
And so now you've waived your financing, you've given up all the service money, and you can't get financing because the seller says, I'm not signing that.
Yeah. Yep, exactly.
Let's go to the next slide. During when the market was really on fire, we saw a lot of post-possession by seller occupancies, and this is kind of a funny one. When lease terms, if you have a lease that expires at the end of June, most of us would think to ourselves, oh, well, that means the tenant is going to move out at the end of June. But in 2021, landlord-tenant rules have changed statewide, and you no longer have a term lease ending as you would expect automatically, or with an email exchange of course you'll be out by the end of the month. And so when there is a lease involved in a transaction, whether it's with a property that you're selling that has a tenant in it, or a property that your buyer is buying that has a tenant in it, or perhaps somebody who's going to be new to landlording, the rules have changed so much that it's quite eye-popping. Selling a home does not give you a right to not extend a lease extension to a tenant. And it's very difficult to remove a tenant once they are in place. So when you establish a tenancy by allowing the seller to stay on, or allowing a buyer to prepossess a property, you're creating a tenancy, and that could very well complicate your life as well as everyone else's life. it goes beyond what's in the lease agreements. The Form 65B or the 65A don't cover this subject in great detail. We're still obligated to do a walkthrough. Let's say that a seller is going to possess post-closing. We still have to give them lead-based paint, mold disclosure, do a moving condition report, and document all of these things. For just a normal tenancy, things have changed substantially where it's no longer good enough a month before the lease term expires to say, well, let's just extend the lease and we'll just do an extension on an extension form. You actually legally need to provide written notice, just like you would in an eviction or a pay or quit. You need to put a separate paper copy through, so for each adult that resides in the building, or in the unit. So if there are 3 roommates in there, you need 3 paper copies with all this official documentation, which can be really quite terrifying for a tenant. We bring this up because as buyer's agents and seller's agents, we rarely get into the nitty gritty of a lease agreement. Maybe we see it come over as part of a transaction. Maybe it says, oh yeah, the property will be vacant upon closing. But what we aren't aware of is these statewide rules that can impact a transaction, that sometimes the notice to terminate that lease, if there is cause, could take anywhere from 60 days to 6 months. And so if there's a lease involved in a transaction in any capacity, be sure you tell everyone to seek legal counsel or talk to someone that has expertise in that area. I've been a landlord for too many years. I found this to be quite disturbing when I found out that a term lease doesn't just end.
And since that's a recent change, you'll want to keep that in mind when you're planning for your listings. I know I've got one coming up and I'm letting my clients know I've got some current rentals that are going to be for sale. And I'm letting my clients know that things have changed. I'm not the expert of that. Definitely confirm with their management company, but just keeping in mind that it's just not so cut and dry. I'm not going to order the staging until I see the people are out. I think we're ready for the next slide. And I think
we talked about this. Yeah, I think we already discussed this one.
Yeah, so we can go to the next slide.
Okay.
Okay. And then when you really want to keep in mind the difference between a rescission and a termination. So you don't want to idly use the Form 51. If you made the mistake and you used the rescission form, you could be liable for costing your client their right to cancel. So you want to, if you have a statutory reason to be able to exit the contract, like rejecting the inspection or one of the Form 90s, resale, Form 17, financing, then you want to send over that cancellation along with the earnest money form. But you just want to be really, really careful and just don't even be really careful even using the word rescission, because I know most of the agents, even when it's a termination, they just automatically say rescission. And so we just don't want to do that. And then also regarding earnest money disputes, you want to do everything that you can possibly do to resolve those disputes, because with the way the courts are currently backed up, criminal court cases are more of a priority. So if you did have to go to an interpleader, it could take 2 years to get there. And it's also a really messy process about who owes what. I believe, correct me if I'm wrong, Lori, I think they said that if somebody requests an interpleader and they don't rule in their favor, can't they also owe court costs?
Yeah, there can be additional expenses associated with it.
So we just really want to do everything we can to resolve those differences. And backing up just a little bit again, to the same with the tenants. When the tenants are due to be out, given how much things have changed, it's just really important to just try to make it work out. Try to be nice. It's not a good time for a landlord to give a tenant a tough time. And they also, going back to the tenant, one other thing, they also said that for tenants, there are free legal services available to them who they said are really good. So again, let's just be nice to everybody and go to the next screen.
So if you are working with a buyer or a seller and they're telling you to do something that is considered high risk, for example, for a buyer to want to give seller post-closing possession, draft an offer without a pre-inspection or no inspection, or remittance money at mutual acceptance, perhaps the seller is giving you consent to receive buyer's inspection report, or this one, allow a buyer to conduct an informational only inspection. These are very, very high risk idea or things to do for a buyer or seller. And you really need to advise your client to seek legal counsel. Real estate attorneys typically cost $300 to $600 an hour and can go up from there. So we need to do everything we can to prepare the documents that we have available to us and use the care of an attorney. And so we want to, proofread, make sure spelling is correct, check the names, make sure what we're saying is correct. Earlier we said having your designated broker, having Rochelle review an addendum. I did this recently with Rochelle. I sent the full addendum via text to her in a text message. She revised it, sent it back to me via text, and came up with some wonderful suggestions. It's so important that we review these things so that we keep our clients away from the courts and away from that $300 or $500 an hour attorney that's going to add up in a hurry, and they're going to be gunning for everyone if it does come to that situation. In regard to seller financing, we rarely see it. Absolutely seek legal counsel. There's just so many things that can go wrong with that. And again, if there's a tenant in the property, don't assume how it's going to turn out because of the tenant landlord rules. Tell your clients to seek proper legal counsel or talk to a property manager or somebody that really knows the ins and outs of the current situation.
Along those lines, thank you. I thought it was also interesting that Annie said the seller never wants to see the buyer's inspection report. So that was interesting.
Never.
Yeah.
Never.
Yeah.
No good comes from that. No good can ever come from that.
She was adamant. And we're ready for the next slide. Go ahead, Lori.
No, please. You go right ahead, Mary.
So agents used to have a habit of telling buyers, you don't pay anything for my service. My service is free. Don't ever say that. And that's something they said several times, is ultimately the buyer is paying for the commission. So we can never say that our services are free, because they are not. So, and then there was also a lot of discussion about copyright photos, and that there are trolls looking through the internet for illegally used photos. So someone owns every photo. Just because a seller gives you a photo to use, they may not have the right to use them. And the damages can be statutory or lots of money. And next slide.
I'll pipe in too on those two, Mary.
Okay. Sure.
As a brokerage, when they changed the whole disclosure on how we have to disclose buyer's agency commissions, our booklets that we use and provide to agents and clients, we had to change all that, because it used to say basically that type of language, or nothing is due until we close on a house, or things like that. And so the verbiage has changed. So you'll see that on our advisory things that we give to clients. It's not just how we say it, it's also how we present and what we show them. So that's certainly on the rise. I will echo that. And the copyright and photos, thankfully, we've not come across this as a brokerage, but I can at least attest to the fact that people are trolling around on the internet, we get probably 1 to 3 a week where people are saying, can you remove this listing photo from our website? And I'm like, that's a syndicated thing from the Northwest MLS from a sold property. I was like, there's no way I can remove that photo. But there's people that are trolling around on the internet like that all the time. So be careful. If you've got a seller saying, hey, can you use this photo that we took of our house 6 months ago when it was sunny, or, you know, when it was in bloom, or when, you know, it looked this certain way, just be very careful to make sure you ask the right questions of, did you take this photo? Was this a photo from a previous listing? Where did this photo come from? And just make sure that you have that from them before you use that photo.
So it sounds like you're saying we should send them an email and have them respond to us by email and keep that in our file.
Yep, exactly. Because you never know. I mean, those trolls that are out there,
Right.
It's best to have something in writing when they do respond. So it's never happened. I would say it's never happened with our brokerage, but there are trolls out there. So don't kid yourself. Just be careful.
And next slide.
I think that's all the.
Oh, is that it?
Yeah.
Okay.
Mm-hmm.
So I think we're done unless there's any questions.
Well, I'll certainly bebop a question over to you guys. So have you guys encountered issues with tenants in the last 6 months, and what's kind of been your experience for that?
That's a great question, because I have a firsthand experience with it. I have a buyer that was buying a duplex, and we got the copy of the lease. So 2 units, one was vacant, the other one was occupied with a lease with a terminating on the end of March. We were going to close at the first week of April. We had a discussion with the agent saying, why the first week of April? It's a little bit long of a closing. We said, because we want the tenant out, the upstairs tenant out. And he goes, oh, that's great. Yeah. And so we possession on closing on the agreement. We thought everyone was set. But you're not allowed, there's no excuse. You have to offer them an extension of their term lease. And so I didn't know that. I just thought if it said be out by the end of March, they would be out by the end of March. And so it caused a lot of strife for the buyer and for the sellers. But just know that there are very few just causes for terminating tenancy, even on a term, and that lease, and that many property managers, that the burden is becoming so challenging and the workload so challenging that many of them, it used to be advantageous to have term leases. Many property managers are now going to month leases because the burden, there's very little difference between the two in most areas. The tenant never left.
Oh gosh.
We'll see what happens in a year.
So I have a question. Mary, are you saying that in a duplex situation, if the contract with the tenant and the landlord has expired, you have to offer them an extension if you purchase a duplex and the tenant
they
is there?
They don't have, and this is Lori, the landlord does not have a right to end that tenancy. The landlord, it can be anywhere from 60 to 90 days, depending if it's Seattle, King County, Auburn, Wood City, Everett. The landlord, 60 days prior to the end of that lease or longer, needs to send a renewal offer, and the tenant has to accept or reject it within 30 days of the termination. And that has to be in paper. That has to be papered on the door of the unit with copies for each adult member. So yeah, the tenant may move out. The tenant may go, it's the end of my lease and I'm just going to leave peacefully. And most people do. But if the tenant doesn't want to leave, the rights are in their favor, and they have every right to stay on.
Okay, that makes sense. Yeah. I've seen the law change towards the favoring tenants' rights over landlord ownership rights.
Right. And it varies by city. And Lori was sharing with me, because Lori does a lot in Seattle, that Seattle is particularly complicated.
Mhm.
They even have rules that conflict with other rules.
Wow.
So we're really not experts.
There's like
Who is right
16
now?
just causes for, now if a tenant doesn't pay or is breaking some other law, it's easier to get them out. But if they're a solid tenant paying their rent on time, selling the property is not an excuse to get them out. You're going to have to find another way to coax them out of there.
Okay, that makes sense.
And we had a really good question too from Dina, I believe, about could we talk a little bit more about the Form 51, which is the rescission form that we're really careful about using.
But let me ask you a question, Mary. I've been involved in over 600 transactions. I don't think I've ever used that form. That's how rare it is. I mean, and I would have to ask, you really have to ask yourself, if you're pulling out a Form 51 rescission form, you should be making a call to Shannon or Rochelle and saying, should I be using this form? It should be the forbidden form, because it's extremely rare to use that form, a rescission versus a termination. If you can't get financing, you do a termination. If you don't like the resale cert, you do a termination. Inspection fails, 35R. If the Form 17 isn't to your liking, there's a form for that. There's a form for almost everything, and you should really know the forms. If you're pulling out a Form 51, you have to ask yourself, what am I doing? Is this the right form?
Right. I think you and I were discussing this earlier, and I think we discussed that basically Form 51, and I agree, definitely talk to your designated broker, but it's more like you don't have a legal out, but the parties have basically both changed their mind.
Or they come to an agreement as
Right.
to, we're going to terminate, we're going to rescind this agreement. We're each going to go our own separate way. And there may be some other consequences or terms that we agree on, but it's a rare form to use.
Right.
I know Rochelle, when she was telling me about the Form 51, I remember when I was new, I was very confused between what's the Form 50 versus the 51? What's the difference between the two? And the best way that she used to explain it to me was 51 is when you have exhausted all other contingencies. It's like you don't have financing, you don't have inspection. People are literally having buyer's remorse, those types of situations. That's when the 51 is used, as terminating all contingencies that you have, versus 50 being just the instructions on what you do with the earnest money. So 50 is used in conjunction with those 90 forms that you have, notice of no no financing available or whatever kind of situation you have. But that's the way that I was taught. And, it is scary. People need to be very wary when they're using the 51, they are removing everything, all the negotiation that was done prior to that point. So yes, thank you, Mary.
You're just putting it in the, you're just putting the spikes in and sending it down. It's gone. It's dead. It's over. We're just killing it finally.
Right. Right. And Alex asked a question about there are photos of my home floating around in the internet. Even if it's my house, I can't use them because I did not take them. And I said, yes, you would need permission from the person that owns the photos, even if it's your home. Right.
A good example that they shared with us was that a landscaper had taken some beautiful photos of the work they did in the yard in bloom. The seller, he gave them to the seller gave them to the agent used them, and the landscaper came back and said, "Those you don't have authorization to use those photos."
Or one I've had in the past is, I listed it 2 years ago or a year ago with this agent or myself or whatever. Can I use those photos? Right. You have to get permission first before. And I think best rule of thumb is that we always just get new professional photography when you have your listings. It's always good to have a fresh image of the house anyway.
Good point. So it sounds like we covered everything.
Yeah, I was going to ask you guys. So when you've got a financed buyer, I know this is like the hot topic of the day. I know I had an agent, I know Fatah, I think came in earlier and he's like, gosh, what am I supposed to do when I've got a financed buyer, but how am I competing against cash? So you guys are writing a lot of offers out there. What have you found to be the best success you've had where you've got a financed buyer, but how can you compete with cash?
I know Lori's done a lot of creative things on that. Lori, I'm going to give that to you. You're welcome.
Many times, thanks. Many times I'll put in, or I will, of course, a buyer will put in that they'll beat on their escalator a competing offer by, $10,000, and then we'll add something like, but we'll beat a buyer who's paying cash with proof of funds by 20,000. I mean, of course, those numbers fill in the blank. Depends on what the price level of the home is. If it's a $2 million home, those numbers are going to be larger. If it's a $500,000 home, they may be smaller. But saying that you'll beat a cash offer with proof of funds, because not just a non-finance, an offer that is just not have a financing contingency. The other thing would be to start sharing details, show assets. Even though we're getting a financing, we're people of means. We're going to be able to cover the difference. Pull out those brokerage accounts and say, if there's a $200,000 or a $400,000 shortfall on appraisal, we got it covered. And be prepared. You can redact the account numbers, but show them that what you can do.
Good point. And also I think even though we want to be super careful about releasing any earnest money, I think even, that's a case where if you're competing with cash, but you're releasing some earnest money, that could make them comfortable too. But it's a slippery slope. And that did come up in the conversation. And they said, attorneys tell you not to do it, but you do it. But if you're releasing earnest money, then you better be using the form that we've got for that. That's not for us to write, but that's something that, that could help. And also I see Dina asked, it seems that most lenders allow a maximum of a 60-day lease back. Yeah, Dina, usually when you go to escrow or when the client sign their documents, they say they're going to move in within 60 days. So I don't think they would like to see more than 60 days. And I don't know, we haven't heard of it yet, but I think it's possible that if an underwriter could see 60 days and in this climate, they could potentially have an issue with it.
Yeah, I think part of it too, with having 65Bs is they're only intended to be short-term rentals. I mean, they're not meant to be long-term type of situations. I know, I think Annie at one point said 30 days or less is kind of rule of thumb when you're using 65As and Bs, but it doesn't cover everything. I mean, what about insurance? If the house blows down or burns down, which has happened to people in the past, it's like, well, who covers what in those types of scenarios? That's why you have 65Bs. So if you've got 1 day, 2 day rent backs, I mean, at least use a 65B. You don't want to just have nothing out there. That's for sure.
Right. And your form 21 says that if they are going to stay longer, they're going to sign the 65B. But the attorneys there said that really our 65B is not a very good form.
No,
it's just not. And keep in mind, it was written before all this craziness and before all these changes. So it hasn't been updated. And what we now know is no matter what they say, it can't undo. We still have to follow the law.
Yeah. Cool. Are there any other questions? So perfect. Thank you so much, Lori and Mary. And for the rest of you, just stay tuned for next Monday. We'll have another excellent webinar on the queue. Other than that, just give us a call if you've got questions. If you're dealing with a burning situation or a question, we're always happy to help and take your phone call. Thanks so much, you guys. We'll see you.